Here's a simple math equation for you as it relates to estate planning. 1 plus 0 equals 1. 1 plus 1 equals 2. Boom! Can you believe it? All right, so what does this mean? This means if you have a will, but you don't have powers of attorney, you only have one thing. If you have a will, which is planning for your death, plus incapacity planning with powers of attorney, then you have two things and you're better covered. 100% of people will die. That includes me. The majority of people at some point will become disabled or incapacitated where they can't make their own decisions anymore. So it's very crucial that you have this second part right here. So don't just do a will. Don't just do a trust. You need to make sure that you also have powers of attorney. Powers of attorney state, if I'm alive but incapacitated, car wreck, coma, heart attack, stroke, Alzheimer's, dementia, something happens where I can't make decisions for myself, whether it's for 24 hours or a week or a month or 10 years, I'm stating in advance, if that happens, who I want to be able to make decisions for me financially. That's generally called a durable power of attorney. And medically, that's generally called a medical power of attorney or a healthcare power of attorney. These are crucial. Many of us will become incapacitated at some point. You want to do this because if you don't do this, it's going to cost a lot of time and a lot of money to be able to get court authorization to be able to make decisions for that person where you're awarded the guardian. And that is, we're talking many thousands of dollars to go through that process and many months of time in Texas and headaches and heartaches and money. So we encourage you to get this done in advance. There's no reason not to. They're easy documents to do, but you got to do them right. And unfortunately, most people do the short form power of attorney, and they really should be doing, in my opinion, my professional opinion, the long form durable power of attorney because it spells out what needs to be done. Other documents that are helpful are the HIPAA release, which says who has access to your healthcare information, the preneed guardianship, if you're ever fully incapacitated and you need a court to appoint a guardian over you, who you want that person to be in the specified order, and whether you want to be buried or cremated, because believe it or not, most parents don't have that conversation with their children. So mom or dad dies and they're like, one child says, oh, they want to be cremated, and the other says buried, and now all of a sudden they're fighting. All you had to do in advance was to state whether you want to be buried or cremated, and you want your ashes spread here or stored on a mantle or buried in this cemetery. But there's a lot of things that you should be doing in addition to death planning that we call incapacity planning. I'm attorney Mike Massey. I love helping Texas families. I've helped over 1,000 of them. I'd love to speak with you. Click below to learn more or look us up at Mike Massey Law.